Welcome to this short documentary on video games and the law. We will be covering types of contracts seen in the gaming industry, professional bodies that are in contact with developer companies, ethical issues in video games, if games have become less or more stringent as time has gone on, and the legal issues that surround video games and the companies that make them. The types of contracts that we are going to cover in this documentary that are seen in the gaming industry are employment, development, licensing, NDA, and collaborations. An employment contract covers the roles, responsibilities, salary, official job title and description, working hours, and employment rights. An example of needing an employment contract is that if someone works for the company and don't have a contract, then they don't have to get paid a fixed fee and get no rights, and can be fired at any moment. A development contract consists of terms, which are things that they have agreed on in the contract, working hours, salary, etc. Ownership, which is to decide who owns the intellectual property. Royalties, which is you agreeing that you will only use franchises that you've got a contract with. An example of a development contract is that if someone is given a particular amount of time to perform some tasks by a company, for example given 6 months to create 6 character models for a game, and they don't complete all those tasks in the time given to them, then they don't legally need to get paid, as the contract was broken. A licensing contract is where you can use a product or service legally, but don't own it. For example, if a company is using a particular piece of software to create a game, then they will need a licensing contract for the company that owns the software for them to use it. Also, gaming companies will need to get licenses to use products in games. For example, the Hollywood sign. It involves the territory of the licensing, which means the product can only be used in a particular area. For example, a game bought in America cannot be used in the UK. It also consists of terms, which means the company that is licensing the product can only use it for as long as the license allows them to. A non-disclosure agreement involves the company that owns a product, for example Activision, and a separate party. This type of contract is to protect the product of the company. An example of this is for large YouTube members to not post any videos of upcoming games, as the game will not be released yet and the company won't want any in-game spoilers to be ruined, as not as many copies will be sold if people already know what happens in the game. A collaboration agreement involves 2 separate parties. It is needed when multiple separate parties come together to create one thing. An example of this will be a game. The game developing company, a company like LEGO and Marvel or DC, will all have to be part of the collaboration agreement. This is so the gaming company can use products owned by Marvel and LEGO. The Entertainment and Leisure Software Publishers Association is an organisation set up in 1989 by British software publishers. It was known as the European Leisure Software Publishers Association until 2002. ELSPA was responsible for introducing video games to the UK in 1994. Only 5% of games didn't comply with the rules of ELSPA during its time. Over 6% of all games given an ELSPA rating by the Video Standards Council were rated as suitable for all ages. Any games that would have a higher age rating than that would be given to the British Board of Film Classification to be given a rating. The Independent Games Developers Association collaborate with current games developers, students, and veterans to the video game industry on a global scale. They welcome all people who are connected to the video games industry into the IGDA. They make changes by addressing issues in the industry, connect students with companies, promote the industry, and connect people all around the world to form a community. The International Game Developers Association is the largest non-profit membership organisation in the world, serving all individuals who create games. Ernest Adams initially developed the IGDA in 1994, first operating under the name Computer Game Developers Association. Women in Games. To give a voice to women in the games industry, they encouraged the roles of positions in the gaming industry to women. This is so women can create games. This is stereotypically a male interest, so this company supports women and backs them up to get into the gaming industry. By having women in the gaming industry, this will allow games to have a different aspect. The British Academy of Film announced they would be making the Games Award its own individual ceremony in 2003. These are a company that awards games companies from indie companies to AAA game companies for their contribution to the gaming industry. The awards include Best Games, Best British Games, and Audio Awards. The Mobile Entertainment Forum is a project created by three friends who wanted to create a forum on the internet with true, honest reviews on all things mobile, as they were getting frustrated by the lack of honesty when it came to reviews online. The Mobile Entertainment Forum was founded in the year 2000. Companies and professional bodies such as PEGI rate every new game before it is released. This is so that buyers have a general idea of what the game is like, so games will be rated 3 if it's suitable for everyone, through to 18, if the game has content such as violence, sexual content, aggressive language, or strong offensive scenes. This is a legal requirement for all games sold to the public, no matter the platform, or if it's sold by disc or digitally. It has now come to a point in society where violence in video games has become the norm. Some groups highly disagree with this. Violence isn't the only problem with a lot of games now. As developers have gotten more riskier as time has gone on, games can now contain content from torture to rape to highly offensive scenes to minority groups. Things like this in video games can get them banned in different countries all around the world, some for very serious reasons and some not so much. Some examples of games that have been banned in different countries are: in Saudi Arabia, Red Dead Redemption was banned as it contains nudity, prostitution, violence and cruelty. Heavy Rain was banned because of nudity and a sex scene. L.A. Noire was banned because of nudity. In Germany, Silent Hill Homecoming was banned because of high-impact violence and cruelty. The Darkness was banned because of Nazi signs in the bonus comic. Wolfenstein was banned because of Nazi references, and Harvester was banned because of high-impact violence and sex references. A couple of less serious games that got banned were The Cat in the Hat in Brazil because of a copyright claim from Discovery Communications, and EA Sports MMA was banned in Denmark because the game promoted energy drinks. Multiple rally groups against violence in video games have put one of the most famous video game series of all time, Grand Theft Auto, under pressure. Grand Theft Auto 5 has already lost millions of dollars due to them adding a police killer simulator. Still sticking with GTA, there was a massive speculation with GTA 3, and the game having to have some missions removed due to the 9/11 attacks. This accusation was denied by Dan Houser, Rockstar VP, after he said in an interview for the GTA 3 10th anniversary that "We made some changes after 9/11, but they were very cosmetic. Most of the delay in releasing the game, which was only a couple of weeks, was a product of the fact that our office in New York was pretty close to Ground Zero, and so any work that had to be done there was made impossible for a period." Another example of a lawsuit against a developer company is Wilson vs. Midway Games. In 1997, a 13-year-old boy named Noah Wilson passed away after his best friend stabbed him in the chest with a kitchen knife, severing his aorta. Noah's mother sued Midway Games, makers of Mortal Kombat, claiming her son's best friend was addicted and obsessed with the fighting game and that he believed he was the character Cyrax, a robotic ninja. Intellectual property, or IP, refers to creations of the mind, such as inventions, literary and artistic works, designs, and symbols, names, and images used in commerce. IP is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit for what they have invented or created. The reason that this is needed is so that people who didn't create the product get credit and then money for creating it even though they didn't. For example, if someone created a video game, and then it would be their intellectual property, and so they should get the money for it. Copyright is a legal term used to describe the rights that creators have over their literary or artistic works. Works covered by copyright range from books, music, paintings, sculpture and films, to computer programs, databases, advertisements, maps, and technical drawings. Copyright protection extends only to expressions and not to ideas, procedures, and methods of operations or mathematical concepts. In most circumstances, copyright does not protect names. A trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. Trademarks are protected by intellectual property rights. A patent protects your invention and lets you take legal action against anyone who makes, uses, sells, or imports your invention without your permission. A patent only protects your invention in the country where the patent is registered. You can register the look of a product you've designed to stop people copying or stealing it. Registered design means you can register the look of a product you've designed to stop people copying or stealing it. The look of your design includes the appearance, physical shape, configuration, or how different parts of a design are arranged together, and the decoration. Registering your design means that it protects any aspect of your design, gives you exclusive right to use it for up to 25 years, and makes taking legal action against infringement and copying more straightforward. To register your design, it must be new, not be offensive, and not make use of protected emblems or flags. PEGI is a company that gives video games an age rating before they are released to the public. Every game needs an age rating so that the buyer knows whether or not it is suitable for that particular person to play. For example, a responsible person wouldn't allow a 5-year-old to play Grand Theft Auto because it has an 18 age rating. The ratings go from 3 to 18 and are affected by things such as violence, strong or offensive language, and sexual scenes within the game. The age rating being higher depending on how graphic the game is. PEGI stands for Pan-European Game Information. Every company needs to put health and safety notices on anything that could affect someone's current mental or physical state, as it's the same for video games. On all games consoles, whether it is as soon as you turn on the console, like PlayStation or the Wii, the player will be warned of things like to take regular breaks when playing the game, or that games played on the console could cause things such as epileptic fits. A lot of games warn the player of the exact same thing, and this is required by every game by law. Otherwise, the game will not only be able to not be sold to the public, but the company may also be fined a lot of money if something happened to one of their customers and it was their fault for not warning them that such an eventuality may arise by playing the game.